I'm a practicing I'm a practicing lawyer and a mediator in the Supreme Court of India, Secretary of the Supreme Court Advocates on Record Association. I welcome you all on day 4 of the 5th International Virtual Mediation Summer School on behalf of Nivaran, mediators of the Supreme Court of India, in collaboration with Singapore International Mediation Center and Commonwealth Lawyers Association. As we navigate the complexities of conflict resolution, it's essential to remember that mediation is not just about finding a solution, but also about how we reach that solution. Ethics play a vital role in ensuring that the mediation process is fair, transparent, and respectful for all the parties involved. In today's conversation, we'll explore about ethics and ethical issues in mediation, ethical principles and issues commonly associated with mediation, such as confidentiality, neutrality, impartiality, and independence, competence, self-determination, conflict of interest, etc. We'll discuss the challenges that mediators face in maintaining ethical standards, upholding the integrity and effectiveness of the mediation process, and examine the importance of ethical decision making. Whether you are a seasoned mediator or just starting a journey in conflict resolution, this conversation will provide valuable insights and practical guidance on how to navigate the ethical landscape of mediation. So let's get started on this important conversation about ethics and ethical issues in mediation, confidentiality, neutrality, and self-determination. For this, I would like to introduce and welcome our esteemed guest faculty, Honorable Lady Justice Joyce Alouch, for today's session. Honorable Lady Justice Joyce Alouch, CBS, EBS, Trailblazer, retired judge, certified international mediator, accredited mediator, certified advanced mediator, and chartered mediator, member, Chartered Institute of Arbitrators, London, and the Kenya branch. Prior to her election as a judge and first vice president of International Criminal Court at The Hague, she was a Court of Appeal, High Court judge, and magistrate in Kenya, having been the second woman to hold the positions. Upon her retirement from the bench in 2018, she successfully moved her legal profession to other forms of alternate dispute resolution. She conducts international mediations, court-annexed mediations in Kenya, and private mediations. She is a patron of women in alternate dispute resolutions. In July 2022, she was appointed a member of Judicial Reform Committee under the revised agreement for the resolution of the conflict in the Republic of South Sudan, charged with the responsibility of reforming the judiciary. She serves in many international regional organizations, including International Advisory Board, Office of the Ombudsman of the United Nations Funds and Programs, co-chair of the Board of Mediators, Beyond Borders International, Board of Member of Dialogue Through Conflict Foundation, Pattern Woman in Alternate Dispute Resolutions, Kenya, and Adjunct Professor, University of Western Cape, South Africa. She is a recipient of several international and national awards, including CBS, EBS, and Trailblazer, awarded by 3 presidents of Kenya. In November 2023, in Florence, Italy, she received an International Peace Award from Premio Internazionale Semplicemente Donna, and in January 2024, was appointed a member of the jury of Semplicemente Donna International Awards. In March 2024, she was appointed to the Global Advisory Council of G100 Global Networking, and in May 2024, the Chartered Institute of Arbitrators, London, appointed her a member of the peer review panel, which investigates and makes reports on the allegations of misconduct of its members. I urge all the participants to take this opportunity and feel free to submit their questions in the chat box, and we'll address them in the question and answer session. I would request our guest, Honorable Ma'am, to start her presentation and enlighten us about today's topic. Over to you, ma'am. Ma'am, please unmute yourself.
Unmute yourself.
Yes, okay. I've just managed to unmute myself. Thank you for inviting me as a guest to speak on this topic. And thank you for that introduction. I'm speaking from Kenya, not the capital city, not any town. I'm speaking right from my village home, but I believe you can hear me. I hope so. Now, my topic, thank you. My topic is ethics and ethical issues in mediation, confidentiality, neutrality, and self-determination. I want to start by just giving my understanding of mediation. And according to my understanding, mediation is a voluntary, flexible process conducted confidentially by a neutral third party who actively assists parties in working towards a negotiated agreement of a dispute or difference, with the parties in ultimate control of the decision to settle and the terms of the settlement. And what about ethics? Because ethics and ethical issues in mediation. I see ethics are the principles, according to me. Ethics are the principles that guide us to make a positive impact through our decisions and actions. This may sound easy, but in reality, it's a complicated task as issues of right and wrong come in. And these issues of right and wrong are dictated by one's perspective and may vary according to culture, moral climate, and individual circumstances. Otherwise, ethics in mediation are crucial to ensuring fairness, transparency, and trust in the process. There are key ethical principles, but before I get there, I just want to pose a few questions for consideration. Can a mediator provide legal advice whilst mediating a case? Can a mediator guarantee a mediation outcome? Can a mediator be paid based on the result of the outcome of the mediation? How can a mediator be neutral while settling, for example, business disputes between large companies and small-scale businesses? How can a mediator conflict of interest be checked? These, I believe, are relevant questions when it comes to ethical issues. Is there an international universal mediation code of ethics? In Kenya, we still do not have, but I'm sure some countries already have. Because mediation lacks governing regulations in many countries, new mediators might find it difficult to fully understand their role and ethical responsibilities. As I said in my introduction a minute ago, mediation is a voluntary, non-binding, structured method of negotiating a dispute with the guidance of a neutral third party, the mediator. The mediator helps facilitate communication, seeks out possible areas of compromise, identifies, defines, and removes roadblocks, so to speak, roadblocks to resolution, and promotes understanding between the parties. Mediation being a flexible process which allows for creativity and ingenuity in problem solving, this flexibility means that mediators can develop their own unique approach. Despite all this, mediation has boundaries, so to speak, and each jurisdiction should have their own conduct, guidelines, and ethics. Standards to guide a mediator as he interacts with a client. A trained professional mediator should act immediately if ethical issues arise, and clients should also take time to understand what to expect from mediator before you hire a mediator. This will help you get somebody knowledgeable and reliable. Given the fact that most clients may not understand the role of a mediator, it is important that in a pre-session, there should be a pre-session in mediation. It's important that in a pre-session meeting, a mediator should carefully explain the mediation process so that parties agree to it and accept it. Parties need to understand their role and the mediator's role and their relationship to the mediator. By the first session, parties should recognize that the mediator is not there to judge or make decisions, but simply to oversee negotiations and help parties to come to their decision. Now, the contingency options. The parties to a mediation should be aware of their full set of options, that there are a full set of options, including other forms of ADR mechanisms like arbitration, conciliation. They should understand the benefits and limitations of mediation and what they can do if they decide not to move forward with mediation or if they are unable to come to a resolution during the process. The terms of agreement. Before an agreement to mediate is signed, and this is crucial, a mediator should take the time to ensure both parties fully understand the parameters of the agreement and their responsibilities within it. If the mediator suspects that there is a misunderstanding, an impairment that prevents full understanding or intimidation to sign, they are obliged to address it. They are obligated to address it immediately. Some parties may not be able to give informed consent. It is up to the mediator to ensure that these parties are not taken advantage of during mediation. And what is informed consent? Is permission granted in full knowledge of the possible consequences. A typical example is that which is given by a patient to a doctor for treatment with knowledge of the possible risks and benefits. That's what I mean when I talk of informed consent. Now, moving forward with my presentation, now, if informed consent, let me finish that. If informed consent is not given by all parties, the mediator should withdraw. Legal advice. I posed a question about legal advice. While some mediators are also lawyers or retired judges, here, for example, here I am a retired judge, and therefore have a firm grasp of the law, they cannot provide legal advice as part of the mediation. This is crucial. If legal questions or issues come up during mediation, the mediator should ask the parties to seek legal advice from their lawyers present in the room or grant an adjournment for that purpose. Similarly, if the case involves other specialized knowledge that goes beyond the scope of the mediator or the parties, the mediators should request the parties to seek out advice on the subject. There is also the possibilities that during the mediation process, the parties may decide to mix mediation and arbitration. The mediators should discuss how this changes their relationship with the parties and whether the parties need to alter what they disclose to the mediator. Parties should be given the opportunity to seek another neutral party to conduct the arbitration process. Safeguard voluntary participation. Mediation is a collaborative process. As such, voluntary participation is vital to its success. Mediators need to conduct sessions in a way that emphasizes and maximizes voluntariness. And because mediation is such a flexible process, it can be adapted to any conflict: workplace conflict, family conflict, medical, parental, landlord, tenant. Most disputes can be mediated. Now, protection of privacy, that is confidentiality. The fact that mediation is a confidential process and conducted without prejudice is fundamental. Being assured of confidence is what makes parties speak openly throughout the mediation process. Confidentiality in mediation is at 2 levels. First, the entire mediation is in confidence. it is held in private. What is discussed remains confidential, and the outcome is only made public if the parties so agree. Secondly, no confidential information shared with a mediator in a private session or private meeting should be shared with, what is shared with one party in a private session cannot be passed without the party's express permission. If during during private sessions or private caucusing, as some people prefer to call it, whatever information comes out during that, you cannot share it with the other party without the permission of the parties that has disclosed it. This places a clear responsibility on the mediator to preserve confidentiality and to treat all information with great care, as once disclosed, the same cannot be taken back. Broadly speaking, there are 3 ways of checking what is confidential. First, asking the party what can be disclosed from the private meetings or private session. Secondly, asking the party what cannot be disclosed from the private meeting. And thirdly, taking the initiative by identifying specific information that may be useful to pass on to the other party and asking for permission to do so. As a mediator, you may find that there's some specific information that may be useful to be passed on, but you got to check first. Revealing confidential information without permission will damage the mediator's credibility and could even end the mediation. So the safest path is to, 1, assume that unless repeated from the papers exchanged or from a joint meeting, everything is said in confidence and cannot be shared. And the mediator must be given specific permission to reveal something to the other party. Secondly, use a summary as a recap for both party and the mediator to check confidentiality at the end of each private meeting. Use a summary. Summarize what has gone on in a private session as a recap for both the party and the mediator to check confidentiality at the end of each private meeting. Now, ownership by the parties. This is important, very important. Self-determination. One of the strengths of mediation is that the parties have a major input into the process and complete control over the final decision. Contrast this with litigation where the system takes over. The parties are sidelined or less central, and someone else determines the outcome. Participation in mediation is voluntary. Parties can pick their own time and choose what they wish to reveal. They can also leave at any time they want. On self-determination, it is the parties who decide the settlement. Although the mediator manages the process, the parties retain the control, direction, and pace of the mediation. The mediator's role is to help the parties find their own settlement. The mediator brings a clear mind to the process, uncluttered by detail and emotion in which the parties often find themselves. That clarity can assist in creating ideas for a settlement. However, the parties need to arrive at their own decision to settle. Neutrality, impartiality, and independence are important assets of a mediator. A good mediator is one who remains neutral and advocates for finding a solution. A mediator is not a representative of either party and should not offer legal advice, even if you are a lawyer, judge, and the parties need to be made aware of this right from the beginning. Parties can choose to have legal representation during mediation. However, if there is one or so unrepresented parties, they should be made aware of their relative position and the limitation of the mediator's role. This should be done right from the beginning. Impartiality as an ethical issue means that a mediator shall not exhibit favoritism or any prejudice towards any party or any position taken by a party in mediation. A mediator should be committed to serve all parties as opposed to serving a single party in exploring the possibilities of a settlement. In the same way, a mediator should be aware of and avoid the potential for bias based on the party's backgrounds, personal attributes, or conduct during the session. All the principles and issues that I have talked about or discussed in a few minutes, they are essential in upholding the integrity and effectiveness of the mediation process. I'm available to answer any questions. Thank you. Is it okay?
Ma'am, the first question is, what should be the role of a mediator when one party is willing to settle the issue and the other party is adamant of not settling the matter because of social pressure of family?
Mediation is voluntary. So if one party is not willing to participate, then the mediator cannot proceed. It is voluntary, and mediator cannot force a party to a settlement. I mean, to take part in mediation.
Also, ma'am, when mediator is aware that the negative decision or failing of a mediation is not good for party and they will repent later, what should be the role of the mediator in that situation?
Sorry, can you put that question again?
Ma'am, when the mediator is aware that a negative decision or failing of mediation is not good for a party and that the party will repent later, what should be the role of the mediator in that situation?
You see, the parties, as I said, they have control on the settlement. They are the ones controlling it. The mediator, it is true that there are some times when you feel that the decision that the parties have arrived at is probably not fair on party A or party B. But as a mediator, you cannot tell them and stop them and say that you cannot sign such agreement because it's not fair on party A or party B, because that's not the role of a mediator. But sometimes it's true, a mediator can feel that way, that this settlement agreement or this settlement arrived at by parties is not fair on party A. But then the mediator has very little option. At least I did have a mediation once where I felt, in my heart, I felt that the decision was not fair on party A. And I asked them several times, have you come to this decision voluntarily? Is that what you want? And they told me, yes, this is what we want. It might sound unfair, but somehow the two of us are agreed on this. So in that case, there was not much I could do, or there wasn't anything I could do, because they agreed on it. And they also, somehow one of them or both of them realized that it was leaning too much on one side, but I couldn't do anything much about it or at all.
Nandini ma'am?
Good evening, ma'am. Ma'am, with your long-standing career as a mediator in private mediations and court and ex-mediators, I just want to ask a question which many times we people face in India. One of the parties sometimes is at a stronger position. You know, they carry some weight. So how do you tackle that situation during mediation?
I think the issues to do with that should come during the pre-mediation meeting, because by that time you have all the relevant documents that have been supplied to you, And you, looking at both of them, you can see that one party stands in a stronger position as opposed to maybe, as I said, a big international construction company, and the other one is a small scale business. And this is where the skills of the mediator come in. You have to handle it in such a way that the less, I don't know whether to call it the less important party, does not feel intimidated. You have to apply your skills, and that is why mediators need to be trained, the skills of a mediator. You need it in a situation like that more than any other situation.
Thank you,
Ma'am,
ma'am.
there is another question. What is
Yes.
what is the agreement which should be signed at the beginning? What that agreement should include actually before the mediation starts?
Agreement to mediate.
That's true.
You need the consent of the parties that they have agreed to mediate. And most of what I've gone through, the ethics, that in mediation, we'll do this, and you cannot do this. And as the mediator, you'll also explain your role. This, all this, that your role as a mediator, you will explain it. And you'll also explain to the parties what is required of them, what is expected of them during the mediation process. So that if all parties, that the parties, whether they are 2, 3, 4, and yourself as the mediator, you understand what you are getting involved in. It's an agreement to mediate. It's not the same as the settlement agreement at the end of it all. Yeah.
And another question, ma'am, how does the role of a mediator change if the parties combine arbitration with mediation proceedings?
Sometimes it happens, and that's why I said, that's why I said that the mediator will explain, and then the mediator would have to look for another neutral, an arbitrator, because you have been conducting this as a mediator, and suddenly circumstances have changed, and the parties seem to be, the parties seem to understand what the circumstances are, has changed. So you cannot really continue as the mediator.
There's another question. With the paradigm shift of dispute resolution from ADR to ODR, how do you see this advancement from convenience from confidentiality point of view?
Sorry, can you speak, can you say it again a bit more clearly? I'm sorry, yeah.
With the paradigm shift of dispute resolution from ADR to ODR, how do you see this advancement come convenience from confidentiality point of view?
Confidentiality cannot be compromised under whatever circumstances. Whether you are in ADR, ODR, confidentiality never changes. You have to, it has to be maintained, the confidentiality. But I haven't personally experienced this changing from ODR to ADR, but as far as I can see, confidentiality, the rule on confidentiality, it cannot change, because then there will be no point in it. It's no longer a mediation.
Ma'am, there is another question.
Yes.
The parties who have come to, who've agreed to come for a mediation would expect legal advice at times to be clear on the law, especially when the parties have been recommended for mediation by the honorable judge.
Yes. Well, during the pre-mediation session, you will make it very clear to the parties that you cannot give legal advice. For me, for example, having been a judge for 44 years, and now I'm into mediation, at the beginning, the parties would be surprised when I tell them I'm here as a mediator, as your mediator, neutral third party, and I cannot offer you any legal advice. But I would say there is one of you is represented, or both of you are represented by lawyers, and they will give the legal advice, or I will grant an adjournment so you can seek legal advice. It has to be made you have to make it very clear from the beginning, before the mediation, as you are addressing them on pre-mediation issues. This is one of the things that you have to talk about, so they know. It took a long time for parties in my country, because I was a judge for a long time here in Kenya for 35 years. And then I was out at the ICC, International Criminal Court, for 9 years. And I picked up, I trained later as a mediator. So it took a long time for parties to accept that I'm in a different situation. I'm a mediator and not a judge, and I cannot give legal advice. No.
Monica ji,
Sorry? I didn't hear that. Yes?
ma'am, your voice is not audible. Monica ji, we can't hear you.
You can't hear me?
No, Monica ma'am.
Oh,
Mridul ma'am, please.
sorry? Are you having problem to hear me?
No.
Rahul has to unmute her.
Achha, Rahul.
Is it me or is it a questioner?
Somebody wants to ask a question. We just telling the person
Okay,
to unmute.
I'll be patient. I'll be patient.
Thank you.
Yeah.
Thank you.
I'll be very patient so that I can hear what she wants to say. I'll be patient, yes.
Until then, you just answer. In your experience, is the presence of lawyers of the parties useful in the mediation or not required?
You know, it really depends on the parties. Some parties come with lawyers, some parties come unrepresented. I personally encourage lawyers if they want to come, but if there are no lawyers, it doesn't make a difference to me whether lawyers are there, because lawyers have their role, and I explain to them what their role is. It's at the beginning, I think, at the beginning of the mediation, it took some lawyers, not all, it took some lawyers time to understand the difference between mediation and maybe arbitration or court process, because they were under the impression that whilst in the mediation session, they could ask questions, they could lead their clients. And so it really depends on the pre-mediation meeting, what you are explaining to lawyers, what their role is. And that's why at the beginning, when I started my mediation practice after retirement from the bench, at the beginning, the lawyers would say, one or two lawyers once asked me, but in these circumstances, Judge, then do I need to be here? I said, you have come with your client, but you call me judge, but here I'm a mediator, because I find it very difficult to convince people in my country here that when I'm in a mediation, I'm not a judge, I am a mediator. But then they keep telling me, but you've been a judge for so many years, we don't know what else to call you. I say, call me a mediator, I'll call my name. So it's really up to the mediator to explain to the lawyers their role in a mediation session. Yeah.
There's another question, ma'am. Can you elaborate more why a mediator cannot give a legal advice, and there is any prohibition on that part?
Well, a mediator is a neutral third party. So how again can a neutral third party be giving advice? The client, sometimes both parties have got lawyers, or sometimes one party has a lawyer, or sometimes none of the parties have lawyers. But whether there's a lawyer in the room or not, that's the rule in mediation, that mediators cannot give legal advice. And by the way, not all mediators are lawyers. Please, not all mediators are lawyers. So when we talk of legal advice, We are only thinking of lawyers, and yet we have quantity surveyors, we have doctors who are mediators, we have all sorts of professions, or some just do not have a profession, and yet they are mediators. They, they conduct community mediations. So I think it's important for us to stress, for me to stress that not all mediators are lawyers. So when we talk of legal advice, we are limiting it to just the lawyers, and that's not what mediation is.
Monica ma'am, I want to ask. Monica Sharma ji. Mridul ma'am.
Yes. I see a hand up.
Sandhanam sir, Mridul ma'am, unmute.
Yes, I am unmuted now.
Yeah.
Yes, good. Good evening, ma'am. This is evening over here, so good evening and the greetings. What I want
Yes.
to know is that normally, usually in our country, we are the lawyers who are mediators. So, in subsequent matters of the parties, can this mediator be a lawyer to that party, and vice versa? That once he was a lawyer to that party, can he mediate another matter? Not the same matter, but another matter.
Yes, I know that there are lawyers. They practice law, but they have also trained as mediators. So sometimes they sit as mediators, they serve as mediators, and sometimes they go to court as lawyers. I know a few like that. Not the same matter as you rightly observe, but different matters. I don't think there's any bar that there's any bar to a lawyer who is a trained mediator conducting mediation in a completely different matter. And a completely different,
different matter for the same party.
I suppose I haven't seen one of that. How do you mean the same party? The same,
Like a matter is there that there's a matrimonial dispute, and
yes,
the mediator is there solving the mediation of the matrimonial dispute. But
yes.
subsequently, one of the parties have their property dispute, and wherein they want to have that mediator as a lawyer.
I think it will depend on circumstances. I'm trying to imagine to picture what you're talking about. Maybe it probably will depend on circumstances.
Okay.
Is that dispute, does it have anything to do with what he mediated over?
No, because that was a suppose that is a matrimonial dispute, and this
Yes.
is one of the parties having the property dispute with his brothers. So I think that
does that property involve the marriage? Is it a property that is got something to do with the...
No. Suppose that matter has been solved between the matrimonial dispute has been solved through court. That is solved, but later on there is a dispute of the brothers of the property. So can that be dealt by the mediator?
If the parties agree that this is the mediator we want, if the parties agree.
Not mediator, as a lawyer. Ma'am, I'm asking as a lawyer. Can he appear as a lawyer later on?
I think the issue that I'm thinking of is, has that matter got anything to do with the previous one? Okay. Or is this just an independent matter where a client comes to consult a lawyer?
Yeah, okay. That's great. Yes. This is your experience, that tells us. Yes, of course. Thank you so much.
Erika? Erika?
Hello, good afternoon, Honorable Lady Justice. Thank you so much for your time. I appreciate your participation. It is invaluable. I have a few questions as a student of law, getting trained traditional way and contemporary way. I'm a student of criminology and the criminal law and human rights in Central Europe at the Pan-European University. And my thesis is comparative penology or chosen aspects of penological comparatistics. My first question would be your personal opinion and your professional opinion about the role of mediation in criminal justice and restorative justice. And my second question would be a role of mediation in area of comparative and empirical approach to justice in regards of access to justice. So we are accessing to justice through the comparative and empirical approaches. How and what is the role of mediation? How can mediation assist us? Thank you.
Good. That's a good question. First is to say that as far as we are concerned in my country, in Kenya, we have not yet started mediation on criminal matters at all. And I believe there are other countries where criminal matters are being mediated, but not yet here. And I suppose one would have to go by if under the criminal justice system, are there any rules? Are there that guide the mediating criminal matters? Are there any are there any safeguards? Are there any directives? Because I don't have that experience, but I believe that there would have to be some guidance on how to conduct criminal or criminal justice mediations under the criminal justice system. And I believe that the way we are going, or the way we are moving in Kenya, we will eventually get there, but not yet there. Yeah. There would have to be some guidelines on how this can be conducted. That's my main point. That is, are there guidelines put in place where such issues can be mediated, or to guide the mediators in this kind of circumstances? Yes. Did I get your point? Are you there? Wow.
Oh, ma'am, the next question is,
Yeah.
what if initially both the parties arrived on an agreement, but later on one of the party backs out as they found that the decision to be unfair? So how should they go about this?
At what stage is one party backing out? They have signed the agreement, because I'll give an example. I have to give an example of where I am now in Kenya. Once a settlement agreement is signed, it's made an order of the court. And when it is an issue of mediation, because the parties discussed it and agreed upon it, then there is no appeal. That's here in Kenya.
It's signed. They've signed it.
Pardon? Sorry?
They've signed the agreement.
Yeah, they signed and the mediator signed also. So it's thereafter made an order of the court under the court annex mediation. But we now have moved further than that, so that private, if parties consult a mediator privately outside the court system, when they reach a settlement agreement, all the parties signed, the mediator signed, even if it did not arise under the court annex mediation, it was a completely private mediation, they can bring it to court and it will be made an order of the court. We have developed that far. Yeah. And thereafter, there is no appeal.
Another question is, ma'am, do you agree that number of sessions should not be barred during mediation process when mediator feels that some settlements could be arrived?
Sorry, do you agree that?
Number of sessions should not be barred during mediation process when mediator feels that some settlement could be arrived.
What session? Did you say moral session? I didn't quite get that word.
Ma'am, can I elaborate? Basically,
Yes.
in court annex mediations, usually a time frame is given. So the question is that can the time frame be increased? If the mediator personally feels that this matter can attain its finality, so can the mediator extend the time? Should he move an application to the court for extension of time, or can he do it? Can he or she?
I think that what I know is that sometimes that like 60 days, and the mediator might find that 60 days are not sufficient. So, you can give the parties more time. The parties might need, maybe instead of 60 days, they might need 70 days or so. And I haven't sent parties back to court to go and ask for more time. I would normally just give them the next date that is suitable to both of them. And if the matter is called out in court, I believe there will always be the issue that, no, this matter went for mediation. It's not yet been finalized. The parties have not reached a settlement agreement, nor have the parties said they no longer want to mediate. So I think time is the parties and the mediator. The parties will control the time. If they want just 2 days, they want more than 2 days, a month, 2 months, it's flexible. I think this is a flexible exercise mechanism. This is a flexible mechanism. Yeah. Shall I take it that that is all?
There's one question, ma'am. Carla
Yes.
Zodia she's raised her hand just to.
Okay.
She wants to ask.
Yes.
Can I go ahead?
Please,
Yes.
please.
Yes.
Thank you. Thank you, Lady Justice Alouch. I'm a neighbor. I'm from Burundi. I'm a lawyer, a senior lawyer from Burundi. And
Wow.
I have a concern of this, a mediator. I'm not a mediator, but I would like to be a mediator.
I hope
working
you
on
will
this.
be. Next time we meet, you will be a trained mediator, yes?
My concern is when the lawyer cannot be an advice, and I cannot give advice. For example, when the decision can be in contrariety with the law, and I think that it can be not easy to execute the decision, to have a decision when the decision cannot be can be in contrariety with some content of law. I don't know if you understand. And also, I think that when I understand the fact that we can have a mediator who is not a lawyer. In that case, don't you think parties need to have lawyers to explain when something can be in contrariety of the law? Yeah.
Good. Parties are free to have lawyers, but you must understand that not all parties can afford lawyers, but they are free to have lawyers. And even those parties who do not have lawyers in a mediation session, if an issue comes that a mediator feels a lawyer should advise the parties, the mediator will give an adjournment so that the parties are free, or that particular party is free to seek legal opinion. And when a party is represented, the lawyer is free to discuss issues with the parties. The mediator will always give lawyers time with their clients. And if there is a situation, I would normally ask the lawyers that on this matter, would you want to speak on behalf of your client? Or would you like do you want a few minutes? I can give all of you a few minutes so that you go and have discussions with your lawyers. Mediation is a flexible exercise. So if there are lawyers in the room, if there are no lawyers in the room, permission will be given to the adjournment will be given to the parties so that they can seek legal opinion. And I'm surprised when you say that a decision would be contrary to the law, and yet there is a lawyer in the room, or one of the parties have a lawyer. I'm surprised that because then what would be the use of that lawyer if a decision is contrary to the law? Because the party that is not represented, I will have given them time to seek legal opinion. And the party that is represented, I would be expecting the lawyer to be giving this party advice, legal advice. That's why this is a flexible exercise. Did I get what you're talking about? Did I get it right? Did I understand you? Yeah.
Maybe not,
Yeah,
because
okay.
I'm a French speaker.
Yeah.
So I try to explain it in an English that can be
Yes.
the particularity necessity
Point is, yes.
of like for example, I give example. Maybe
Yes.
they can parties they can take the decision to for paying money.
Yes.
And this money they can maybe decide to be paid in US dollars. And
Yes.
and your country and the law of the country does not allow to have a payment or an agreement on such currency. Only in the currency of the
in local
of
currency, yes.
in local currency, yes.
Yeah.
That's how what if I'm a lawyer and I'm a mediator and they agreed on the payment in US dollars, I think I will have in my view, I will have not to suggest not to have such decision on paying in US dollars, because it will be contrary on the law of the country.
The land.
Yes.
Yes,
That's what I was explaining. Not giving
I see. But this party, okay. These parties, let's say they are Kenyans or they are Rwandese, and they know that the currency in the country is dollar, or Rwanda. I don't know whether your currency, Kenya shilling, let me put it that way. So by the time that they are agreeing on payment in dollars, when that is not allowed in the country, these are issues that maybe the mediator will have explained at the beginning, that whatever agreement you come to, you know that it is illegal to pay in dollars or it is legal to pay in pound sterling. So whatever you agreed on will be in a currency that is acceptable in the country. Something like that you will have explained to them, because if they're indigenous, they will know that in this country we cannot operate in pound sterling, we cannot operate in dollars, we can only operate in Kenya shillings or Rwandese dollar or something. So these are things that a mediator can explain, so that they don't go so far as to be agreeing that you'll be paying me this in dollars, you'll pay me installments in dollars, when that currency is not accepted in that country. Did I understand right?
Yes, thank you. If I understand better, you have some information to be given in pre-mediation, but if this is not done, you can just give such information when they are still we are in the private when the mediation has started, right?
Yeah, you can give that information in private sessions also, but but it can happen, but it would be unusual that a mediator and the parties involved do not know that this currency is not permitted in this country. But I suppose it can happen. Yeah.
Thank you.
Any more question? Rahul, please unmute Erica. Rahul, please unmute Erica.
Are we done? Any
No,
more?
just the last question.
Okay, I'll give time. Yes.
Just the last question.
Lovely. Thank you so much. Unfortunately, I cannot unmute myself by myself. Lady Justice, Your Honor, thank you so much for your time. I wanted to thank you that you fully answered my question. So towards the guidelines, early 2 days back, our wonderful participants and the panels, they have mentioned that thanks to Commonwealth Lawyers Association, which I'm a member of several committees and subcommittees, there is a process of when the mediation will be signed by all Commonwealth countries. Therefore, the mediation would come the second largest occupation, legal occupation, and therefore it is already a mainstream. And we have talked about it yesterday, that why, and day before, why is mediation still considered to be an alternative form of dispute resolution if it has more than 6,000 years old history? So perhaps can you please mention the history of mediation and reflection of the history of the mediation and alternative dispute resolution in your village, in your country? Thank you. Thank you very much for your time.
Yes, traditionally in communities, mediation has always been there. Their own way of, communities' own ways of conducting mediations. And now that for the last 1.5 years, I have been conducting judicial reforms in South Sudan, I found that even there, it's the same thing, that traditionally, communities have been conducting mediation. And that's the same as what has been going on in Kenya. It is only under our current constitution of 2010 that a provision was now inserted in the constitution, Article 159 2C, that now makes it mandates Article 159 2C. It now made it, it brought it up. And before that, there was nothing that was guiding it. In a minute, I'll probably read out to you the exact wording of that article if I can find it quickly. I'd like you to have the exact wording of it that now makes it, that made it possible, and that it was under that that court annex mediation after after amending the necessary sections in the civil procedure, it made it possible for the court annex mediation to be put in place. It is a provision in the current constitution in Kenya. I'm just trying to get the words. Give me a minute or so that I read the exact wording of our constitution when it comes to mediation. Article is Article, okay, 159, let's see. Article 159 2C is I have authority when I quote what is exactly in the constitution. Article 159 2C. And what does it say? Let's see. 159 2C. It's the article that brought in the alternative dispute resolution mechanisms in the Constitution of Kenya, Article 59 2C. Just ask another question, I'll read it out to you. I wanted to read the exact wording so that you see how it eventually, Article 159 2C, not 2D. Sorry, I'm not able to get it, but I wanted to give you the exact wording. And that is what has enabled us, that's us really given it gives the jurisdiction to the courts to apply ADR, including traditional mechanisms. And currently the Chief Justice has even expanded it. Let's see. Sorry, I'm not able to get it easily, but I wanted to give you the exact word. If you can just Google Article 1592C of the Kenya Constitution 210, you will get the exact wording. Otherwise, mediation traditionally was always there amongst the communities. They did it in their own way and it worked somehow, but now it was given constitutional force by this article of 159 2C of the current Kenya Constitution 210. Okay? Yeah.
Thank you, ma'am, for taking us on this important journey into the world of ethics and ethical issues in mediation. So from today's session, we've learned that ethics are the foundation of a successful and trustworthy mediation process. Ethics matters in mediation. Impartiality, confidentiality, and neutrality are the key principles. Mediation is not just about resolving disputes, but about doing so with integrity. As mediators, let's commit to upholding the highest ethical standards, fostering trust, and promoting fairness in all our interactions. On behalf of Nivaran, mediators of the Supreme Court of India, in collaboration with Singapore International Mediation Center and Commonwealth Lawyers Association, I would like to extend our sincerest gratitude to our distinguished speaker, Honorable Lady Justice Joyce Alouch, for sharing her invaluable expertise and insights on ethics and ethical issues in mediation. Ma'am, your presentation was enlightening, informative, and thought-provoking. We sincerely appreciate that you took out valuable time for this interaction. To our participants, I thank you all for active participation, engaging questions, and enthusiastic engagement throughout the virtual lecture. Your input and feedback are invaluable to us, and we are grateful for your interest in this important topic. Thank you, Rahul and his team, for all the technical assistance. Before signing off, I would thank you all again for your time, expertise, and enthusiasm. We look forward to our next virtual lecture and hope you would join us again tomorrow. The topic for tomorrow is an overview of conflict and styles of conflict, conflict management, resolution and transformation, being delivered by our guest speaker, Sarah M. Blake, conflict strategist and mediator. Thank you.
Thank you. And once again, thank you for inviting me to be part of this exercise, this important exercise. Thank you.
Thank you, ma'am.
Bye.